have a right to say no because too many guilty people are saying yes. So this is what the memo that went out from the Department of Law. So the Brown case comes down to this. Would you read this for me, Recruit Alexander?
An officer conducting a routine traffic stop may not request permission to conduct a search that is unrelated to the basis of the stop or not otherwise supported by a reasonable suspicion of criminality.
Yes, sir.
Is this specific to Alaska then?
Yeah.
Okay, so
Every
tried federally though, or she was?
the feds don't enforce traffic laws
I'm sorry.
unless it's on unless it's an unless it's on federal land.
How
So
did the whole argument come up where Alaska would give her more rights?
that's the whole constitutional thing we're talking about with the Supremacy Clause. The 14th Amendment says states can't afford their citizens fewer protections against government intrusion than the U.S. Constitution. And then the follow-up question on that slide was, well, can they give them more? And the answer is yes.
Okay. And then they can't be held accountable to
Now, okay. And then Kid Johnson raised the question about, well, what about that in the Supremacy Clause? And you're not going to like this explanation because it just basically is, well, that's the way it is. The Supremacy Clause deals with relationships between the federal government and the states. The 14th Amendment phrase that we just read, cannot abridge, the 14th Amendment deals with relations amongst not just the federal government and states, but also United States citizens. So Supremacy Clause deals with two governmental entities. State government, federal government. Federal government wins. The 14th Amendment, by its language, brings in the citizens into the formula. So laws that state constitutions, either case decisions or their constitutions, are allowed to give more rights to citizens that live in their state than the federal. They just can't give fewer. And because their constitution, as ours does, has this express right to privacy that doesn't have to be read into it or implied. Because our Constitution grants more rights to Alaska citizens than the federal Constitution, our state Supreme Court, who interprets our Constitution, can interpret it as granting more rights, just not fewer. We can't give fewer rights than the U.S. So, and the only explanation for how that escapes the Supremacy Clause is it's governed by the phrase in the 14th Amendment if it deals with granting rights to citizens, if citizens are in the formula, not just two governments. Because the 14th Amendment just wins over the Supremacy Clause when citizen rights are involved. So let me just get a pretest question out of the way, and then I'll respond to Recruit Lopez. So, given this pretest question, now we've been talking in terms of the rights of citizens. Can give more, not less. The pretest question applies that concept to you. And the pretest question is, can the Alaska Constitution give police more power over citizens than the federal Constitution? What do you think, Rubio? Right, because you having more power means less individual rights for the citizen. You're the government entity in that. So but I wanted you to understand how that applies to you. We can't give you more power because that was with the Brown thing, because that would afford less protection against the power of the police acting as the government. Did that take care of your question, Recruit Lopez?
No, ma'am. My question was, let's say I do a traffic stop or the same situation, a light is out. Can I ask the operator if there are drugs in the car or weapons?
You stopped them for... Yes. I believe you can. That's one prosecutor's opinion. I'm not, wait a second. Because they said, you're not asking consent to search.
Right, I'm just,
You're asking them.
I'm asking a straight, do you have any weapons or drugs in the car?
I believe you can. I could be wrong. You cannot ask them to search.
Right.
But I believe, number one, you can always ask about anything that has to do with officer safety. Right. The drugs is the only one yes, I believe you can ask.
Is the question itself not a search, though? Because
well, but what they're saying is you can't request permission to conduct a search. They haven't said you can't ask them. So, in my opinion, now, if we routinely start doing that and we routinely have guilty people saying yes, who knows? We're going to have another criminal court of appeals case. And you know judges are lawyers, right? And you can't get two lawyers to agree to kill a rat in a bathtub. So that's just my opinion. But number one, I got no problem with the weapons.
Now, based on their response, could I develop reasonable suspicion because of their...
You better be able to articulate it. Yes, you better be able to articulate it. And it's going to have to be a nervousness that goes beyond the nervousness we all experience in a traffic stop. We're all nervous when you stop us. We express nervousness in different ways. Some of us are just pissed. What chicken shit thing have you stopped me for? What? I got a light out on my tag, like Susan Brown, or like you said. Yes, you may develop reasonable suspicion of criminality that then would allow you to ask permission to search. Keep in mind, and this will be seared in your brain when I come back and I cross-examine a few of you folks in our winning courtroom confrontation, keep in mind you will be asked on cross-examination to articulate that. And if all you describe is exactly what the judge would be exhibiting, if you stop the judge, we're going to be in trouble.
So is that called articulable suspicion?
Yeah, that means you better be able to articulate it. And I want all of your articulable suspicion in your report. Otherwise, they do a real good job on cross-examination suggesting that you're adding it now after your meeting with the prosecutor because you didn't have it at the time. And now all of a sudden, 6 months later, and how many car stops later, you're remembering this stuff that wasn't significant enough to be in your report. Gee, is that because the prosecutor said we're dealing with a motion to suppress because there's not enough in your report?
Right. Now, what about the support of an audio recorder and you articulating on the scene that, sir, why are you averting your eyes from me? Why are you looking in the back of your vehicle?
Great. Great.
Well, what you're saying is if I approach a vehicle and give the greeting of the day and, exchanging information, I say, sir, do you have any weapons or anything I should know about in the vehicle? And they just simply blankly say, I have a bag of weed or like a kilo of cocaine in the trunk. I mean, without like showing any nervousness or anything like that.
If they say I have a bag of cocaine in the trunk, you're good to go.
I'm confused on what the difference is. I'm just really confused right now.
What? And I don't want to bog down in this. No. What Recruit Lopez says is, can I ask, do you have any weapons or drugs in the car? I can't ask to search. Under Brown, I can't ask to search. Look at the final bullet point. I can't ask to search without one of those. What he's saying is, if I ask permissible questions that provide reasonable suspicion of criminality, then may I ask consent to search, and my answer is yes. But you better be able to articulate the reasonable suspicion that is developing with these permissible questions. Does that make sense?
Yeah, I was just confused about why you said you have to be more nervous than a typical car stop.
Because everybody's nervous when you stop them.
Right.
They're nervous about the traffic stop.
That doesn't mean they're a kilo.
That doesn't indicate that kind of nervousness, I don't think, provides reasonable suspicion of some other kind of criminality. So what he articulated great. It said, when I asked, well, what about drugs? That's when his eyes went to the console and he looked up, and that's when he started getting nervous and he wouldn't look me in the eye. And then I'm even going to want you to follow up with something. Gee, I noticed, yeah, that's great. I noticed, you know, you.
I understand. I think I was just mixing up facts. And
Okay.
I think we will have support in the future because in the future you would be able to say, based on my training experience I've conducted over X number of traffic stops, this person was noticeably more nervous than any other person.
But you know, when I come back, we're going to talk about this nervousness thing on the stand. Describe the behavior. It paints a clearer picture that distinguishes that person from if you stop the judge.
You have to have that suspicion before asking them to do it.
Before asking for consent. But you can, what the point Lopez made, which is an excellent point, is you can develop that suspicion during the stop. It's not an all or nothing thing when you first approach them. When you first approach them, you may not have reasonable suspicion of criminal activity beyond the traffic violation. So you cannot, and Brown says you may not ask consent to search until you develop reasonable suspicion of criminality. But that may occur during that stop, at which point in time you may then ask them for consent to search. But you better, because of Brown, we know our court is really nervous about this. They don't like random, no basis, just figure, roll the dice, and I know people consent for, I don't know why, because they're guilty, but they do. You better be able to articulate at the point in time what your suspicion is of criminality other than the traffic stop, that you felt justified. In this case, I asked consent to search because of this. No, I don't do it randomly. I know I'm not allowed to. But in this case, I did because I developed that. Recruit Rubio.
So does a recognizable scent or odor fall into that same category of reasonable suspicion?
You're earning it, man. You're earning it. Yes, those are all the kinds of things. Yeah, Cheech and Chong. Oh, good. Some of you do know Cheech. Good. Cheech and Chong have survived the 60s. Yeah, I mean, they roll down the window and they got a toke this big, like a Havana cigar. Or they're going, yes, officer. We got reasonable suspicion, okay? Yes.
Does this also apply to houses, or is it just traffic stops?
This is traffic stops. We're starting to get into search and seizure stuff that you're going to have so much more time, more training on, and I still have to cover this and yeah. Brown applies to traffic stops under that narrow kind of thing. Good question. You're going to get a ton of stuff about homes. Okay. Just to make sure we've nailed this. Pretest question. An officer conducting a routine traffic stop, and look at the slide, may conduct a search unrelated to the stop or officer safety as long as the officer requests and receives permission from the person the officer stopped. True or false?
False.
Anybody not tracking? Good. All right. Recruit Lopez. Let's tackle another section of the 14th Amendment.
Nor shall any state deny to any person within its jurisdiction the equal protection of the laws.
So, scenario 9. Hate crime legislation. What did you guys come up with? Well, first, does anybody want to try to tell me what the two different arguments are? Or somebody tell me what the argument is supporting hate crime legislation. Somebody tell me what the argument is against hate crime legislation. Okay, which do you want to take, Tilly?
For it, man, we discussed last night as a group, couldn't really think of a really good, valid reason
For
having, hate crime stipulation, other than just the way America feels, it would be morally right, just based on what has happened in our history. That's about the only thing that.
anybody have a more see what's going to happen? And this case went. This was a real case. Well, hate crime legislation came out of Matthew Shepard, a gay guy, being like hung on barbed wire fence in the middle of the winter in Montana and beaten and left to die a torturous death. Black churches being burned, synagogues being blown up and burned. So can anybody, and so we get this hate crime legislation. The actual case where hate crime got upheld was a black on white crime that actually went up to the Supreme Court and was decided whether hate crime deprived certain criminals of equal protection under the laws. Can somebody think of so then you go in and you've got the government arguing a compelling interest it has, and then the other side arguing why it's unconstitutional under the Equal Protection Clause. Can somebody broaden the argument for the government as to why we would have a different interest in crime that is directed because of somebody's race, gender, ethnicity, religion? Can anybody think of the broader, Eccleston?
Maybe just simply the motivation, whereas like.
No, take it away from the person, the motivation, to the victim. Recruit Rubio.
Well, if the victim happened to be the same race and ethnicity and religion and all those things as the person who committed the crime against them, but it was the same exact crime, but it's a different punishment, it seems like it would be unfair.
You're making the argument for why it violates equal protection. We'll get there, and remember that argument. Remember that argument. Give me the and then I'm just going to give it. If you don't get it, because we got to move on.
The mental state is what we're trying to.
Okay. Here's what the government. Yeah, you want to? Then I got to move on.
Oh man, just to not incite further violence, like if the government's basically.
Oh, that's a good thing. That's it.
They don't want the other group to backlash.
That's a good argument. But here's what the court said, and think about this. If you're looking at the effect of the crime, and we do that all the time with victim impact statements, right? The effect of the crime on society. If Bresnahan assaults me, Bresnahan assaults Burdick for no reason having to do with Burdick's age, race, ethnicity, or anything, then that doesn't freak out Bo Hatch. That doesn't freak out Burkett, right? But if Burkett assaults some Hall, because Hall is, I don't even know what your ethnicity is. Pardon? Okay, because he's black, and that's the reason. Every other black person feels they're going to be next, feels less safe. What do you think a community feels like when a Jewish synagogue or a Jewish daycare center is burned because they're Jewish? A black church is burned to the ground because it's a black church. It doesn't just victimize that victim. It victimizes everybody else who has the same characteristic as that hate-directed crime. It makes us all, it expands the victim group hugely. And that is the main argument in favor. I think yours is an additional one. Because it expands that, then to feel safe, they may become vigilant, whatever. But if we have this stronger reaction, they're going to feel like, you understand, I got to be made to feel safe. So there's got to be a deterrence here for, okay. Now, Recruit Rubio made part of the argument on the other side. You want to add to the argument about why it violates the 14th Amendment and the First Amendment?
Certainly. Well, as already mentioned, it sets up protected classes of citizens who are entitled to more protection from the law if they are, for example, assaulted than others. As we talked about yesterday, laws have to be applied fairly, and this law historically has not been applied fairly, which is a point against it. And then you also mentioned several times yesterday unintended consequences that can accompany a law. And this one certainly puts us on a slippery slope where we begin thinking about criminalizing hate speech, which is an infringement on the First Amendment, as you talked about. We're heading down a very dangerous direction by setting up protected classes, protected types of behavior or thought or whatever, and criminalizing a motive for committing something that's already a crime. An assault is an assault. I mean, when is it not a hate crime? If a husband assaults his wife, is that not something of a hate crime?
You have an alternative career available to you. I'm serious. If you I hope you have a long, wonderful career as one of Alaska's finest, a peace officer. But when you retire from that because your knees don't do what they need to do anymore or some other reason, go to law school. Okay. Now, I'm sorry. We got to get through this stuff, or you're going to be here in the evening. You said it. The other side said they didn't phrase it as equal protection violated in terms of giving more protection to a special class. They instead looked at the suspect and said it violates my equal protection right because I'm going to be the enhanced penalties are pretty significant. I've got an Arizona case, newspaper article, where instead of doing 2 years, it's 5 years for an assault on a gay guy while they were screaming gay epithets. So it's not insignificant. And they're saying the assault is the same. What you're giving me 3 more years in jail for what I'm thinking? How about First Amendment? And hate crime punishments chill First Amendment speech because if I'm out there giving a speech against faggots and then I later assault somebody who's gay, my speech is protected. You're going to use it as evidence against me to give me 3 more years in jail. Protected speech, chilling effect. It's going to chill people from speech they otherwise would have speech they would otherwise have protected. Well, Wilson versus Mitchell, the U.S. Supreme Court, black on white crime, some black use. Watched a movie of horrific racial violence against blacks that our history is replete with, and they ended up beating up a teenage white kid. And there was a hate crime, and here's what the court held. Punishing the conduct of the assault, it punishes the conduct of the assault. That's not protected by First Amendment. They said the state's desire to address this greater victim harm was a compelling interest. And they said the chilling effect on First Amendment speech was too speculative. And I agree with that. That people wouldn't say things because they'd be afraid it would be used against them later when they committed an offense. The First Amendment doesn't keep defendant statements out of other criminal trials as evidence. So if, for example, if a person says, out loud, I always wondered what it would be like to rape someone or have sex with a kid or stab someone to death or shoplift, that's not criminal. That's all protected speech. But if they later act on that, we can get that in as evidence of their culpable mental state. And they're saying this is no different. Those statements aren't punishable as a crime, just like standing on a corner railing about faggots is not punishable as a crime. But other statements can be used as evidence of the criminal act, and that's the balancing act they did. Number one, we use other First Amendment protected speech as evidence of crimes and the compelling interest for the larger victim group, we think justifies it. We can agree or not. Alaska has one, but Alaska's statutory aggravator covers race, sex, color, creed, physical or mental disability, ancestry or origin. It doesn't cover sexual or gender orientation. And I am available for any discussion. I love questions, but I hope you will understand the need I have to get us through the material. I don't like to squelch questions. And I trust your judgment. If it's something you really think we need to share with the group, go, ooh, but this one is really, you need to, okay? You really need to cover this one. So, how about reading that question for us, those questions for us, Recruit Andy?
What about curfew laws? What about crack enhancements? Enhanced penalties for drugs to minors or on school grounds?
I already addressed enhanced crack enhancements yesterday. The argument is always, the argument on these has been equal protection. Curfew laws with kids, equal protection. Just because we're a kid doesn't mean our freedom of movement should be restricted. Anchorage a few years ago tried to pass a curfew law. Where they get upheld is where, I mean, you have to give the reason. Okay, so people say the reason is to protect youth. That was one of the things with the Anchorage curfew law. And then, so the court says, okay, provide me empirical data evidence that youth are more at risk, more often victim of crimes or more often perpetrators of crimes during the hours you want them off the street. We couldn't do it. I don't mean we. Whoever wanted this curfew law could not provide that. So, well, then it's not going to justify limiting their freedom of movement. Penalties for drugs to minors on school grounds. Dope dealers are saying, why should I get punished more because I sell to kids than adults? They lost that one. Well, we afford all kinds of special protections to kids. But the argument comes under 14th Amendment equal protection. It gets litigated. The courts decide. And would you read this, please? Let's just start with Akana, then I can keep track.
Nor shall any state deprive any person of life, liberty, or property without due process of law.
So, what does due process require? This is from court decisions because the 14th Amendment doesn't tell us. So we get all these appeals and things get litigated, and here's what the courts have decided due process requires. Now, Recruit Barrett obviously made an executive decision to let me get through constitutional law before he took a break, yes?
Yes, ma'am.
I appreciate. That's taking command and control and owning your authority. Let's take a 10-minute break, and when we come back, we'll jump into